Just want to say welcome to the second session, and the title of our class is Dialogue and Perspectives on Advanced Planning. To introduce myself, my name is Makoto Kotani, and I am the Director of Programs at Keiro. And I would like to use this time to also introduce our expert speakers on the panel today. We'll have Tomohiro, Tommy, Kagami to your far left, and then we have Mei Kameda in the middle. Briefly about Tommy. Tommy is an attorney specializing in probate administration and litigation, trust administration and litigation, conservatorships, and estate planning. He counsels clients on all aspects of probate, trust, and conservatorships, including fiduciary appointments and removals, marshaling of assets and sales of assets within trusts, conservatorships and estates, and fiduciary accountings. He has resolved and settled numerous disputes involving fiduciary appointments and accounts, asset management and distributions, interpretation of validity of estate plans, and fiduciary compensation. Welcome, Tommy, and thank you for being on the panel. Mei Kameda is a licensed clinical social worker who works in the field of palliative care and hospice. She holds a Master's of Social Work from California State University in Long Beach and completed an Advanced Practice Palliative Care Certificate for Social Workers through Shiley Institute for Palliative Care. Her areas of interest include normalizing experiences of grief, health bioethics, and the use of language in healthcare settings to promote patient-centered, inclusive delivery of care. Please join me in welcoming our speakers for today. So now that we've heard a little bit more about our speakers, I wanted to give our speakers a chance to get to know our audience a little bit. Alongside our registration for today's Caregiver Conference, we asked a couple questions, including at what stage are you a caregiver, and who are you caring for? So I know that many of us on our name badges may have ribbons that indicate if you are a current caregiver. Would you be willing to raise your hand if you are a current caregiver and you have a purple badge? So it looks like to me maybe just about half or so are currently caregiving. We also have another color that indicates that you will provide care in the future with the silver badge. Does anybody have that on their name badge? You will provide care. Okay, so maybe about a third of our audience. Along the registration, actually what was interesting was, besides who's in the room, we actually had 52% of our registrants say that they are currently a caregiver, and surprisingly, 22% of people said that they plan on providing care for someone in the future. We also asked if people are going to receive care or if they're currently receiving care, so that kind of makes up the full spectrum of people attending our Caregiver Conference for today. And if I can get a show of hands, who is caring for maybe an aging parent, an older adult parent of theirs? Okay, a fair number of hands. Is anybody caring for a spouse? Could be a partner, husband, wife. A fair number. And then for those of you who aren't caring, maybe I just want to ask, who is not currently caring for someone right now, but is planning on caring for someone in the future? Any hands there? Very good to know. So just for our panelists to kind of get a sense of who's in the audience, we have people attending the Caregiver Conference. That helps us understand, they will provide care, they are providing care, and maybe they even expect to provide care or be provided care in the future. So as an introduction to our session, one of the interesting findings we had was over 60% of adults in the United States have at least, or over 60% have not completed at least one advanced care planning document. So to kind of also understand who we have, if you have completed at least one advanced care planning document, would you be willing to raise your hand if you've completed at least one? So I see a fair number of hands, but we also have people who maybe have not completed those documents, and that's exactly what this session is for today, right? To start thinking about it, to start having conversations, and to really get the planning started. So I'm looking forward to seeing how we can bring each of your expertises into the conversation. And I actually want to start us out by asking each of you, what is advanced care planning and what does it mean to you, kind of using your profession and your background to help explain that. So what does advanced healthcare, advanced care planning mean to you? And we can start with Tommy.
Sure. So thank you for having us, Makoto, and thank you, Keiro, for organizing this and having us present here today. Super important topic. So advanced healthcare directives, it's an opportunity for you as the principal, as the person preparing the document, to express your wishes about who you want to, what are your care decisions, who do you want to make care decisions for you in the event you're not able to do so. It also, since it's an advanced directive, it's also a document that allows you to decide about your end-of-life decisions. Do you want to withhold or withdraw certain types of treatment towards the end of your life? It also allows you to make decisions and indicate your wishes about what do you, after you pass away, do you want to do any kind of organ donation? Or what about, do you authorize autopsy of your body? So the Advanced Healthcare Directive is an instrument that works for you during your life, but also after you pass away, it tells the healthcare providers as who do you want handling certain types of decisions for you. So it's a very important document, and it's rather than having the courts provide or make a decision for you, it's since you're alive right now, it's best if you can indicate your decisions.
Great, thank you so much, Tommy, for providing that context. And May, anything else you wanted to add?
Yeah, along with what Tommy said, I always like to give like a general definition what an advanced care planning is, and it's a process to help people kind of plan for their future about their healthcare decisions in case you become very ill or have an unexpected life event or a complication of your chronic illness where you're not able to make decisions on your own, to have like a plan in place so your wishes can be honored and the right people are advocating and speaking on behalf of you.
Great, thank you so much. And so now that we have kind of a basic understanding of what advanced care planning is, how does that come into play in the line of work that each of you are in, right? Estate planning, being an attorney, Tommy, and then for your experiences, May, as a social worker, where does advanced care planning have a place in each of your experiences?
So I do the planning side and also the court process as well. So generally clients come into my office and they're asking, hey, I think I need to address my estate planning. And generally, you know, it's setting up a trust, setting up your will, but also the Advanced Healthcare Directive and Power of Attorney for finance. Those are documents that come into place. The Advanced Healthcare Directive, generally, it's the Power of Attorney and the Advanced Healthcare Directive. These are two instruments that are effective while the person is still alive. So upon your passing, it's no longer effective. But to the extent that you're able to express your wishes of who do you want making care decisions for you, what types of cares do you want to receive, you're able to indicate all of that. So on the planning side of things, the Advanced Healthcare Directive always comes into play. But on the flip side, so when someone passes away, although there may be some disputes about, well, who gets to make the decision about the disposition of my remains? This comes into play. Sometimes it sometimes can develop into a heated debate. Maybe one child thinks that the deceased mom should be buried at a cemetery, and the other child thinks no, she needs to go back to Japan, be cremated, and go back to Japan in a certain temple, a family temple. When it comes to an Advanced Healthcare Directive, the person on the document, the agent whose name on the document, actually has priority under the law. So again, the Advanced Healthcare Directive is a super important instrument in indicating what your wishes are and who's going to be that decision maker. Also, the situation worldwide is that medicine's getting better, people are living longer, but it might be a situation where your mental capacity is waning. Maybe you've developed Alzheimer's dementia or other types of dementia, and you have capacity issues. The Advanced Healthcare Directive is a way for the courts, if a conservatorship is necessary, for the courts to see what your intent was as to healthcare. Because sometimes the healthcare directive, you can, through the healthcare directive, you can actually indicate who do you want as your conservator of the person making care decisions for you. So it's a document that's important on the court aspects as well.
Yeah, thank you for providing that context. And May, in your line of work?
Yeah, so I work in the field of palliative care and hospice. So a lot of the patients that I see are living with a serious illness. So some people already have an existing advance directive, and we work collaboratively with the patient and their loved ones and their healthcare agent to kind of learn about who they are as people and try to kind of figure out what is most important to them as they're reaching a certain chapter of their life. And in addition, we also have these several goals of care conversation in the hospital with the patient, the healthcare agent, family members, and friends and loved ones. And it's oftentimes very helpful to have an advance directive in case we have patients that are not able to kind of voice their wishes because of their illness. And we have a person that we can go to who knows a person, who honors and respects their wishes when they're having a tough medical situation.
Yeah, definitely. So, I think if you have an advanced healthcare directive in place, it's important that your loved ones likely know about this and that you communicate your wishes to them, that they're understanding that they are listed as an agent as well. What are some other things to consider through the advanced care planning process, or other thoughts that you'd like to share with our audience today? Understanding that many of them are caregivers or expecting to be caregivers, how can people start to think about advanced care planning if they haven't already?
I just wanted to first say it's a really tough conversation to have. And it's even tougher when our loved ones don't want to have that conversation. So I always think that it's a process. I wanted to also acknowledge a space that sometimes there's a sense of urgency, especially when our loved ones are very, very ill. So, I want to acknowledge that there is sometimes an urgency to have these conversations or execute these documents, but it's always a process. It's an ongoing, fluid process that people kind of have to go through, to have an open dialogue.
Yeah, it's, by the time clients come to my office to talk about estate planning, they've kind of firmed up their decision. They're set on doing their estate planning, and when I explain to them that we're also going to be preparing their advanced healthcare directive, they've pretty much given some thought about that. But not all clients are alike. Some might need more time to decide. Oftentimes, I have a lot of Japanese-speaking clients, and then perhaps all of their family members, relatives, close ones are in Japan, and they really don't have anybody here. They have friends out here, friends that they trust, which are good candidates, but they haven't quite, they don't have any family member out here, and they really want family to be involved in the decision making, so they need more time. I try to tell the clients to try to engage their loved ones, reach out, have that conversation, because it might actually spark up a discussion about the availability of that individual. Are they capable of doing, even persons that you might think as candidates for being the agent under Advanced Healthcare Directive, maybe their life circumstances have changed, that they're not able to, or maybe they've freed up sometime and they're able to be involved. So the important thing is to have that discussion with your family, with the people that you entrust, to see to talk about your advanced healthcare directive and if they're willing. But it's just having that conversation.
Can I add a little bit? When you said, Tommy, about the people that you trust, I wanted to point out that your healthcare agent doesn't have to be family. I've had patients who appointed their friend. I've had patients who appointed their in-laws, because everyone has a very unique family system, and when you're completing one, you want to think about what's what works best for me in my given situation.
Yeah, definitely good points. And I think something to acknowledge too, right, is these aren't easy conversations to have. They're not dinner conversations that you just casually have on a Friday night. So understanding that it can be a challenge. What are some challenges that you recognize? And then what are some ways to help overcome those challenges through each of your perspectives?
I think the biggest challenge is people don't really want to talk about when they're reaching the last chapter of their life or when they're very ill. People don't want to think about that. It's a really scary thought to have, and I want to fully recognize that. Some things that helped I've seen in my personal life and in my professional life is depending, and this is very general, right? Because every person is different and everyone's state of readiness is different. Some examples that I've seen before is if, my friend had a very, ill family member who didn't want to talk about these things, but they were watching a TV show and, there was a scene in like the medical setting. They're like, do you want this? And they were like, no, I don't want this. And they didn't press more. They kind of like let that go, and then they had an opportunity later on to talk about, you mentioned to me earlier, a few weeks ago, that this was not acceptable for you. Have you thought about that? And keeping like an open-ended question to see what their state of readiness is. So that's something that I've seen that helped for some people.
Yeah. So, and then just for the audience as well, we will have some time for audience questions at the end. But I just wanted to be able to have each of our speakers offer their perspectives to many of the situations we may be facing through our caregiving journeys. So, as far as other challenges with advanced care planning goes, we asked the audience earlier, how many of you have an advanced healthcare directive? I want to kind of be more specific now. How many in the audience have an advanced healthcare directive? That's actually a fair number, I would say. And maybe a different question I would ask is, how many of you have updated those documents in the last 3 years? Okay, and I would say this is not a bad thing at all. Maybe we can speak to some of those experiences. It's not a set and forget type of deal. What are some situations where we might consider reconsidering or looking back at what we've put down? And then what are some examples that each of you can share about that process?
Yes, so like Makoto said, it's not a one and done. The important thing is that you've addressed it, but a good time to revisit your advanced healthcare directive is changes in your life. Perhaps there is a death in the family. Maybe one of the agents that you named in the document has passed away. Or maybe they are receiving care themselves, and so they're not probably a suitable candidate for you to become your care provider or agent. Maybe you created the document when you were younger, and let's say you had children who were minors at the time. Well, you're not going to ask a 12-year-old to take care of you, so you've named other family members, friends, as agents, but now your children have grown and hopefully they're mature, and they'll make the right decision for mom and dad. And so now you want to change that. And so age is also a factor. And also, it's always nice to not only revisit your advanced healthcare directive, but also with your other planning documents, like your will, like your trust. So sometimes you might not be thinking about your healthcare directive, but maybe something has happened on the finance side through your trust, where maybe you've received an inheritance, and you're addressing your trust document. But that's always a good time to update your advanced healthcare directive, even if you don't make any changes. And the reason for that is there's so many documents when you do your estate planning documents. You want to make sure that most of those documents are recent, but it also helps if all the dates on the documents are are the same dates. So if you did it on January 1st of this year, perfect. You know which document to look for rather than, oh, the power of attorney is from 24 and my advanced healthcare directive is from 23 and my trust is from 2000. It's all over the place. So revisiting it with your planning attorney and revamping all of it all at once is not a bad idea. How often should you do it? There is no set rule, but when there's a life-changing circumstance, that's a good time to take a look at it.
And if I may kind of follow up and represent an audience question potentially, what is the cost of that? Or what kind of fees or expenses would be incurred?
So I could only speak for myself. It's rare that you're only going to be changing your advanced healthcare directive. Most likely you're going to do your entire estate planning. So every estate planning attorney, every firm out there, they do it differently. Some have a set fixed fee. Some do it at an hourly rate. It really depends. There are also providers out there online like LegalZoom and other online providers. I think those are great resources. Would I use them? Probably not. The only reason is your circumstances, your family dynamics, your assets, everything is different. So the estate planning document, you want to custom craft it. So it's always best to seek out legal advice, paralegals and attorneys to get those documents updated. For my firm, we do everything hourly. If it was just purely just doing your advanced healthcare directive, probably it's going to be somewhere around $300 just to update that. But it's rare that it's just an advanced healthcare directive that you're preparing. If it's a full estate planning package, there's a lot of documents we create. Our firm would probably go somewhere around $3,500 to $4,000 to do the advanced care. To do your planning documents.
Is that for the initial time, or is that for every kind of time you're updating your materials?
Right. So the price range that I gave, and again, every firm does it differently, but for us, that's document preparation. So if the client has multiple meetings, multiple telephone conferences, emails going back and forth, and let's say the process takes 3 years. Well, it will be more expensive with that interaction. But generally, we try to keep these meetings succinct and short, so that we're not just having a long conversation. But if you need to readdress it later on, hopefully the conversations will be shorter, since all the documents, all the provisions are already in your previous documents.
And then just a quick follow-up, and then I want to get back to May as well. But can you talk to us, Tommy, a little bit about how the initial setup cost may be, let's say, $3,500 to $4,500, but what are the consequences to not having that set up? I know you have experience and expertise in probate as well. What is the disadvantage of not having certain documents set up?
Sure. So, so probate comes in when you have assets that need to pass on to either through your will, pass on to your loved ones, whoever you indicated as your beneficiary, or if you don't have a will, it goes through intestacy. But current law is if you have assets over $184,500 in your individual name, and so individual name meaning it's not held jointly, like in a joint account, it's not in a trust, or it's not like a life insurance where you designate a death beneficiary. So it's just purely in your name. And you combine all the assets, and if the sum of all that is over $184,500, it's going to go through probate. And the mechanics of a trust is you want to put most assets in the trust so that upon your passing, you avoid probate. You keep it out of the courts, you do things privately. Probates are not necessarily a bad thing, but it is a long process. It generally takes anywhere from a year to about 2 years. It also is, anything filed with the courts means it's public record. So if you don't want your neighbors finding out what assets you have, probably best to keep it private by setting up a trust. And then cost. What does it cost for a probate? Generally, the law says It's on a statutory fee basis, so it depends on the size of the estate. So for example, if it's $1 million estate that you have, you own a home, couple bank accounts, maybe an investment account, you combine all that. If it's $1 million, the attorney gets automatically $23,000, no question asked. The administrator handling your estate also gets $23,000. So right off the bat, you're in $46,000, and then you start adding court filing fees, appraiser costs. You know, that's another $4,000 or $5,000. It's easily a $50,000 ordeal. If you compare the price, setting up your trust, that includes your advanced healthcare directive, $3,000, $4,000, to doing $1 million probate, probably best to set up your estate planning. The advanced healthcare directive, though, specifically, if you don't have one, or even if you did have one, a situation might arise where, let's say you do develop some kind of cognitive impairment, you have Alzheimer's dementia, and you are refusing, the person is refusing assistance, and there is a need for court intervention, then that's where a conservatorship comes into play. And conservatorships are very, very, very expensive. Why? Because you are essentially asking the courts to take away somebody's constitutional rights to make their own healthcare decisions, their own financial decisions. So the courts, in the process, the courts are very, very careful of addressing, is a conservatorship really necessary? And if one is, who should be that conservator? And this is where the Advanced Healthcare Directive really comes into play. If you have your Advanced Healthcare Directive, you're most likely going to indicate who you want as to be your conservator, what kind of care decisions you want made. And that document, the Advanced Healthcare Directive, comes into play through the court process where the judge will acknowledge and say, this individual wanted end-of-life decisions as such, or wanted to name this person and that person as the conservator to make care decisions for them. So again, the Advanced Healthcare Directive is an important document to have. It is also the first step to avoid a conservatorship too, because usually that document, if you have the Advanced Healthcare Directive, it's going to state, in the case that I can't make any decisions for myself, who's going to handle it? You've already named that agent. It's only when the hospitals and care providers refuse the Advanced Healthcare Directive because the patient is combative, refusing assistance, that a conservatorship might be necessary. But in the end, having an Advanced Healthcare Directive is better than not having one.
Great, thank you for the very robust response there, Tommy. It's a lot. It's a lot to think about, is what I'll say, right? And because it is a lot to think about, I think that can, on its own, be the barrier to have these conversations. So maybe, May, if you wanted to respond to any of the challenges that you've seen and some of the ways to overcome those challenges.
Yeah. Well, I wanted to say that when you're completing like a pre-made form like this, you can actually complete this for free. Sorry, Tommy.
Very true.
However, I have had people who wanted very like personalized, specific documents, and that's when I recommend people to go with an attorney to have them sit with you and talk your very specific original advanced directive. So it's really up to the individual's choice which route they pick. So I wanted to point that out a little bit. And I also wanted to share that these conversations are very fluid, right? So I've had people who were like, I need to do this document, right? And we do it. And then the next day they're like, I thought about it and I changed my mind. And they want to redo it the next day. And that's acceptable as well. Because we all have our own thought process. We have our lived experience that is unique to our individual self. And it's normal to ponder about these really important decisions and change it whenever you want to. That's within your right. So that's something that I really try to stress with people, that it's okay to have fluid thoughts about what I would want with my healthcare decisions. How to overcome challenges? I think the biggest thing is to really normalize having these tough conversations. I don't go to the coffee shop and say, hey, let's talk about how we want to die, when we're like really sick, right? That's very morbid. But, having a casual conversation with a friend or a family member and not make it like very too strict, I think that's really helpful. Just to kind of having a conversation and a dialogue. You don't have to be like, we need to do this form right now, but just having a conversation, I think, will be really helpful. And if I also learned that before kind of inviting someone to or suggesting to do a advance directive to other people, it's really important to think about yourself and like really self-reflect on what's important to me, who's important to my life that will honor and respect my wishes the most. And then if you're ready, having the document and then having the ongoing discussion.
Yeah, definitely. And then, Tommy, based on May's response, any thoughts or any additional comments?
Well, I think. Let's move on to the next one.
So another way to go about this too is, how do we start having these conversations, right? They're not easy to have. You're not going to just have it over coffee. But what are some ways to make these conversations either more approachable, or ways or strategies that you've seen that may have worked in your personal or professional experiences?
Yeah, I think I'm just gonna say it depends, right? Because each of us are each individuals. I think the start of the conversation, for some people, I've had people who are like, I've had a death in the family, and that's an opportunity for us as families to talk about these things because of whatever the experience it was. I've also had people who read about it or hear other people's story where they feel a little bit more like inspired to have those kind of conversations with families. And I also want to point out the death deck that Keiro has at their table. It's like a little card that has prompts to talk about your wishes and your values and what's most important to me as a human being. And these death decks are also like a fun, kind of non-threatening way to have really difficult conversation in a more lighter way.
I think what I want to share from the legal side is, the more you wait on doing your advanced healthcare directive or planning, it does become difficult, because what does it all hinge upon? It hinges upon your intent. So let's say you're coming across a situation where the person you're caring for or yourself, you are starting to have forgetfulness, short-term memory loss. Then it calls into question, did that person really have capacity when they executed that advanced healthcare directive? And another example might be, let's say that the patient is now in a skilled nursing facility, not a assisted living facility, not a boarding care, but they're actually at a skilled nursing facility. California law has it that if you are going to have a patient at a skilled nursing facility do or redo their advanced healthcare directive, it's not as simple as signing and dating and having 2 witnesses, which are the normal requirements for an advanced healthcare directive. It actually is going to require an ombudsman from the LA, if it's LA County, from LA County. You're going to have to contact the ombudsman's office to have a patient advocate present, either as a second witness or yet an additional witness to the instrument. So it's more of a hassle. And the reason why the ombudsman gets involved is they want to make sure that patients being cared for at the highest level, like a skilled nursing facility, are not being taken advantage of. So it acts as a layer of protection, but it also means another hurdle that you have to overcome before you can do some planning for your loved one or for yourself. So trying to address it earlier on, it would help you not have to overcome that hurdle. A different way to approach that question.
Definitely. And something I want to share with everyone, if you are at the conference today, you should have received a conference bag. And inside the conference bag, there is a green file holder. Inside that file holder is a copy of a blank Advanced Healthcare Directive to be able to follow along to see, what the document entails, what are some of the sections you need to consider. So if you haven't already taken a look at it, please take a look at that. And maybe in reference to the Advanced Healthcare Directive, Tommy, you mentioned the 2 witnesses to be able to kind of like authorize the execution of the document. What can the 2 of you tell us about the 2 witnesses versus the notary aspect of it?
Yeah, so from a legal perspective, either is fine. So if everybody has this Advanced Healthcare Directive, this is actually a form that I use. Some attorneys like to prepare a 20-page Advanced Healthcare Directive. Who wants to read 20 pages? Does a hospital really going to spend time going through 20 pages to figure out who to contact? I like using this form because it's a form that's very simplified. It gets right to the point. A lot of healthcare providers, hospitals, doctors, they know this form. They've seen this form. So they know if you go to a certain page, they're going to find the information they're looking for. So if you go to like page 7, where it says Statement of Witness, you'll see on there, it says 6A, Statement of Witness. There, you have first witness, second witness. Your Advanced Healthcare Directive to be a valid document just needs to be witnessed by 2 witnesses who are adults. But if you don't have witnesses, you can also, on the next page, on page 8, just execute this document in the presence of a notary public, and it's a valid document.
I also wanted to share that there's several different advanced directives, like these pre-made forms available, and some cost money, some don't, some you can just download it for free on the website. I really like the ones, like the 5 wishes. I'm not sure if anyone has heard of it. I see some head nods. And, for some people, these like straight, no, like just very simple, boom, 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 my healthcare agent, these are my wishes, sign, works for you, and that's okay. And for some people, like for me, I really like things that talks about who am I as a person, what's most important to me, and how I want to be remembered, when I die eventually. So there are like different unique advanced directives out there, and all of them are valid. It just really depends on your preference, what kind of forms are important to you and something that you would want your families to keep.
Yeah, definitely. And then I guess the distinction I want to make is you don't have to get it both authorized at the notary public and have the 2 witnesses. It could be either or.
That is correct, yeah. It could be either or. Another one that I just want to quickly touch upon is page 3. It says number 2, authority of agent. So, this is a kind of a laundry list of what you are authorizing your agent to do for you. Make decisions about your care, your health, medication, surgery. And at the very end, you see a box there that says optional. Generally, advanced healthcare directives come into effect when the patient or the principal loses capacity, and you have the physician sign off and say, yes, this individual can no longer make care decisions for themselves. That's when it pops up, and then the named agent can start making care decisions for you. Well, this box, if it's checked and if it's signed below, it makes this document effective immediately. I tend to advise my clients that, and I explain the differences, but I tend to advise my clients to have this box checked and have this line signed. Why? Because there may be a situation such as you're rushed into the emergency room, and the hospital there requires 3 physicians to sign off saying that this patient that just came in doesn't have capacity before the Advanced Healthcare Directive becomes effective. Well, there's only one standing physician there at the emergency room. They're waiting for 2 other physicians to come down. And 20 minutes roll by, and it may be a situation where they needed to immediately make a medical decision or do an operation. And after 20 minutes, that option, that window, may have closed. If this box is checked and the hospital makes a quick decision that yes, this person cannot make a decision on their behalf. They will then be able to contact the agents on this form to start making the decisions on the patient's behalf. Doesn't necessarily mean, the hesitancy that I find sometimes for people to check this off is, well, wait a minute. If I check this box off and I sign this, does that mean that the hospital's not going to listen to me if I'm wide awake? The answer is no. The doctors, the hospital there will always, always, always defer to the patient first, and as long as you're coherent and you're able to express your wishes, they're going to listen to you. Even if you check off this box, they're not going to say, oh, sorry, you signed away all your decision making. We're not going to listen to you. We're going to listen to your agent. That will never be the case. So this is there just so that you can speed up the process.
Yeah, I also wanted to touch base on page 7 of the statement of witness as well. It's really important to read that paragraph, the statement of witness, because there were times where I've had the healthcare agent sign as a witness or a family member sign as a witness. And Tommy, maybe you can clarify who can sign as a witness, whether family members can sign as a witness or not. But it's really, or a healthcare provider of the person creating the advance directive be a witness. And then, you know, I have to seek legal guidance, and they're like, you know what, May, this is an invalid document, you know? So it's really important to read these documents. And if you have questions about the wording of the document, I always highly encourage people to seek guidance from an attorney to make sure that you fully understand before signing any document. So I wanted to just point that point out.
Yeah, so, you know, as far as witnesses, one, they have to be adults. You can't have a 17-year-old child act as a witness. It's always nice to have a disinterested individual be a witness. The point is, you want to prove to the judge or in a courtroom proceeding, if it comes to that this document, there was no undue influence. It was done out of your own volition. It's all voluntary. So having disinterested witnesses is nice. Can it be family members? Yes. But in terms of healthcare providers, so doctors and hospital staff, they generally cannot become witnesses to the Advanced Healthcare Directive. Same goes for staff or staff at like assisted living, boarding care, or skilled nursing facility. They generally cannot be signing on as witness unless they're actually blood related to the patient. Then they can. So, but just to avoid all that complexity, having a disinterested witness. So, I'm not going to say pull people from the street and say, hey, can you witness my advanced healthcare directive? But you know, people you trust or your circle of friends, and say, hey, I need you to witness an important document I'm going to sign. That might be a good way to get some disinterested witnesses coming in. And then events like this, you know, it's nice to have a community setting like this, and Keiro does a really great job of doing that. So when there's events like this, and if you've made some connections, this is a good setting to reach out to others and say, hey, look, I'd like you to be a part of my planning documents. Would you sit in? And then, you know, it might spark new conversations as well as to your planning.
Yeah, definitely. May, did you have any other additional thoughts you wanted to share here?
I really like when Tommy said, like, it's good to do in a group setting because it's less scary when we have people kind of having the similar kind of goal to complete a document. It doesn't feel as alone. So I really do think it's not for everyone. Some people like to do things privately, and I think that's totally valid. But for people who kind of want to do in a group setting, that's really helpful. And I've seen people go to like a support group, and they all mutually agree to be each other's witness and complete it at the end of the support group. So I just wanted to point out that that can happen too, and it works for other people.
Yeah, definitely. And I know earlier we said these aren't conversations you have over dinner. Actually, at 1 o'clock we'll have lunch, and then over lunch, perhaps you might want to revisit some of these conversations. There are over 100 attendees today who may be able to act as your witness, potentially. So why not have some of those conversations? I do want to make sure we have enough time for some audience questions, if there are any. But I do want to ask each of you one more question, and that would just be, what are things you want the audience today to take away from the talk? Whether it's on advanced care planning, just overall, in the caregiving space, what are some things you want the audience to walk away from this session understanding?
Yeah, I think if you have your advanced healthcare directive or planning documents, I would like for you to take a moment of your day and just take a look at it, review it, make sure that everything you have in there comports with what you want going forward. And then if it doesn't, or maybe you need to seek some advice, reach out to an attorney or to one of these community or foundation to ask about does your planning document needs to be addressed or not. But it's revisiting your documents, I think, is a good thing. And for those of you who don't have planning documents, start thinking about it. Start having these conversations. It's definitely a step in the right direction. It doesn't happen overnight, but it's just knowing that these instruments are out there, and they're out there so that you can express your wishes. It's only going to help you. It's not there to negatively impact you.
Thank you, Tommy. May?
Yeah, for me, I just want the audience to know that what you want matters. And each of us, what an acceptable quality of life can mean different for each of us because of our own unique lived experience and perspectives in lives. So it's normal to have different opinions about how I want my life to look like at the end of my life. And it's okay to have differences, and that your voice matters is something that I wanted to say.
Very powerful words. Thank you. So at this time, if there are any audience questions, we do have a little bit of time reserved. We'll have Kent coming around with a microphone.
In your example of those critical 20 minutes, and if you're alone from like a accident or something, you're not carrying around your directive. How do they know?
Very good question. So what I advise my clients, as far as advanced healthcare directives, if you do have a primary care physician, or if you have, if you go to regularly go to a hospital, before the 20-minute in the accident, but provide them with a copy already. The system nowadays is that these advanced healthcare directives, they get loaded up into the system. It's associated with your social security number, so that so it's definitely care providers in the network. They will be able to pull it up even if you're not going to that same hospital. But it also is accessible by other non-network providers. So it's good to give it to your care providers or hospitals. For the ladies, if you do carry a purse, a handbag, a copy of your advanced healthcare directive is just as effective as the original document. So have one in your purse. The gentlemen, I wouldn't say carry it around in your back pocket, but if you have a cell phone, now these documents can be digitized. You can have a digital copy in your cell phone, and if they're able to access it, they might be able to click on a file. But for your question, in that 20 minutes, yes, it is a difficult situation. It might be a situation where you do have it in your handbag, let's say, or you have it located somewhere in a file that says health, medical related, so that they can the first responders can quickly take a look at it and gain that access. But here's the thing. If in that situation, if you are taken to the hospital, let's say you don't have your healthcare directive, the responsibility by law for the healthcare provider hospital is that within that 24-hour window, they do try to look for your loved ones or family members, and they will try to locate, if there is one, an advanced healthcare directive. That's a requirement for the hospitals to do. But normally they will reach out to family members, whoever they can find, or it might be a friend, and they will reach out to that individual. So one way or another, they'll try to get a hold of somebody. Try.
Great, thank you, Tommy. Any other questions? I see a few hands.
This is going to be a bizarre one. How legally binding are tattoos? For do not resuscitate. I also have one that says I'm an organ donor, because what if I get separated from my driver's license? and they can't find my family members. At least it'll start a conversation.
Yeah, well, let's say, yeah, you know, you're an organ donor, and that's what you truly intend, but you don't have the Advanced Healthcare Directive handy with you. The general rule is if they can't identify your intent to be an organ donor, then I hope not. The general rule is that they will not donate your organs. Hopefully you can have your instrument with you. Don't lose your driver's license, and then provide your healthcare provider with the advanced healthcare. And I forgot, what was the first part of your question?
Like a do not necessitate tattoo on your shoulder.
Oh, yeah, I mean, so until the hospitals can actually locate or find out from your family members about your wishes, the general rule is if you are in that situation where a ventilator might be necessary, they'll put it on, even if your wish is withhold life-sustaining treatment. They'll do it. Actually, that's an experience I'll share with mine. I lost my father to pancreatic cancer, and even before he went into a coma, I was sitting next to him on the bed and saying, "Hey, Dad, I'll see you tomorrow morning." And by the time I got there the next day, he had the ventilator on, he was in a comatose state, and his wishes were to withhold life-sustaining treatment. But that doesn't mean that the hospital is immediately going to say, oh, it says withhold life-sustaining treatment, let's take off the ventilator and not do anything. They don't do that. They generally have the ventilator on. When the family can congregate and say their last goodbyes, collectively, the family will give the okay, and that's when they'll take off the ventilator. So protocol, I think, and every hospital is different, but protocol, I think, would be that they will keep it on just enough time for the family members to gather around and collectively make that decision. Sorry for the long answer.
I think we have time for 2 more questions. Back.
What's the relationship between this document, the advanced care, and the hot pink form?
So yeah, the POST form is a physician's order for life-sustaining treatment. And that form is typically completed for a person who is living with a serious illness by a physician. So it's a physician's order. So it's a little bit different than an advance directive, because an advance directive, you're appointing someone to make a decision for you on behalf of you, right? The POST form, the pink form that you put on your fridge, it's a physician order that has different section about what kind of attempt resuscitation, do not resuscitate, what kind of medical treatment you want, whether you want artificial nutrition, and there is a section at the bottom that talks about whether that person has an advance directive or not, and then you can put your healthcare agent on the side. So let's say something happens at home, paramedics come in, they find the pink form, they know they have an advance directive and this is the person, so they know who to reach during emergencies.
Thank you. And then we have time for 1 more question for right now. Anybody want to raise your hand if you have a question?
If it's dated 5 years ago, say, on the advance directive, is it still legal, or is it still accepted? When
Yes.
things have changed, a witness has died or whatever, when things have changed, but it's dated, so is that acceptable?
Yes, there is no end date, effective date for an advanced healthcare directive, even if it's a document that you executed 20 years ago. If that's the last existing document, it is effective. So let's say it's a situation where there's 5 advanced healthcare directives, and which one do they use? They always are going to use the last dated instrument. So the one that is most recent, it's going to revoke all the prior instruments.
Great question. So I want to take this time to say thank you so much to Tommy and May for being here, presenting from your professional and personal backgrounds. I just want to say on behalf of Keiro, thank you so much for being part of this session. At this point in time, I do want to also give you all an opportunity to get ready for the bento lunch and resource fair. So within your name badges, you should have a blue ticket if you wanted to get that ready to go in exchange for your bento. And I also do want to call attention to inside your program booklet that you received for today, there should be a pink paper. That is the conference evaluation. So as you sit down for lunch or after you pick up your bento, please start to fill out that pink paper evaluation. It also has an opportunity drawing, and you can provide any feedback you have for us. At this point in time, I just again want to say thank you so much to Tommy, to May, for helping us with the session. We have some volunteers in place to help guide you to the gym, where the resource fair is also taking place. So please take a look at the resources available at the resource fair. I believe Tommy's firm is there, among other aging resources. Take a look at the Keiro table as well if you wanted any conversation starters on the death there. Just again, thank you so much for attending today's Caregiver Conference. We'll see you in the gym and at the resource fair. Thank you.